Let's look at the second of the prohibited acts under the Convention definition of genocide, B, causing serious bodily injury or mental harm to members of the group. For this prohibited act, there has to be an impact. It must cause serious bodily or mental harm. The harm doesn't have to result in permanent or irremediable harm and doesn't need to result in grave and long-term damage, but disadvantage to a person's ability to lead a normal and constructive life is going to be evidence of serious bodily and mental harm. And you can see the court examining this in the trial chamber decisions of Kirstich at the ICTY and Akayesu at the ICTR in particular. The cause of the serious bodily or mental harm needs to be physical or mental acts of cruelty, and some examples include torture, inhuman or degrading treatment, rape, deportation, enslavement, starvation, and persecution. It could include other acts of similarly cruel treatment that involves harm that goes beyond temporary unhappiness, embarrassment, or mild humiliation, an example of which would be detention in a ghetto in conditions designed to cause a people group's degradation, deprivation of rights as human beings, and to suppress that group and cause them inhuman suffering and torture. The ICC elements for the crime of genocide by causing serious bodily or mental harm include the perpetrator caused serious bodily or mental harm to one or more persons. This conduct may include, but is not necessarily restricted to, acts of torture, rape, sexual violence, or inhuman or degrading treatment. Such person or persons belonged to a particular national, ethnical, racial, or religious group, so a protected group. The perpetrator intended to destroy in whole or in part that national, ethnical, racial, or religious group as such. There's the dolus specialis. The conduct took place in the context of a manifest pattern of similar conduct directed against that group or was conduct that could itself effect such destruction. The Akayesu case at the ICTR was the first to find rape and sexual assault as a form of genocide under B, the prohibited act of causing serious bodily injury or mental harm to members of the group. The court in the trial chamber said, quote, "Indeed, rape and sexual violence certainly constitute infliction of serious bodily and mental harm on the victims and are even, according to the trial chamber, one of the worst ways of inflicting harm on the victim as he or she suffers both bodily and mental harm. Sexual violence was an integral part of the process of destruction, specifically targeting Tutsi women and specifically contributing to their destruction and to the destruction of the Tutsi group as a whole." We'll look at the Akayesu case and others from the ICTR more in Class 6. Let's look at the third prohibited act under the Convention definition of genocide. C, deliberately inflicting on the group conditions of life calculated to bring about its physical destruction in whole or in part. This particular prohibited act relates to indirect attempts at extermination in the long term. You don't have to have culminated in achieving the desired objective. So an example would be subjecting a group of people to a subsistence diet, systematic expulsion from home, and reduction of essential medical services below the minimum requirement, or denial of access to water and benefits. The aim is physical destruction, but the result is not actually required, so immediate death is not necessary. The terms deliberately and calculated add a specific mental element to this particular prohibited act, but you still need the overall dolus specialis, the mens rea, that, the specific intent to destroy in whole or in part the national, ethnical, racial, or religious group. To date, no ad hoc tribunal has found genocide to have occurred under C, this prohibited act. The ICC elements for the crime of genocide by deliberately inflicting conditions of life calculated to bring about physical destruction include the perpetrator inflicted certain conditions of life upon one or more persons, that such person or persons belonged to a particular national, ethnical, racial, or religious group, that the perpetrator intended to destroy in whole or in part that national, ethnical, racial, or religious group as such, that the conditions of life were calculated to bring about the physical destruction of that group in whole or in part. And the term conditions of life may include, but is not necessarily restricted to, deliberate deprivation of resources indispensable for survival, such as food or medical services, or systematic expulsion from homes. And then finally, the conduct took place in the context of a manifest pattern of similar conduct directed against the group or was conduct that could itself effect such destruction. Now, that phrase manifest pattern that you see in the ICC's elements of the crime is unique to the ICC's elements of crime and is not actually part of the customary international law definition. In this, that's also the case that it applies to prohibited acts A and B as well. The case of Bosnia versus Serbia at the ICJ actually looked at the potential crime of genocide pursuant to the Prohibited Act C, deliberately inflicting on the group conditions of life calculated to bring about the physical destruction. In support of these allegations, Bosnia argued that Serbia had allegedly encircled and shelled and starved the population during the siege of Sarajevo. The ICJ accepted that this happened, but it said that this also happens in wartime, and not every war is genocide. So for that, the court couldn't find the specific dolus specialis for genocide. Bosnia also said that there was ethnic cleansing. The court accepted that it happened, but again, no dolus specialis. Bosnia said that there were camps. The court said, yes, we accept that happened, but there was no dolus specialis. And finally, Bosnia said that there was deliberate destruction of historical, religious, and cultural property. The ICJ accepted that this happened, but said, quote, destruction of historical, religious, and cultural heritage cannot be constituted to constitute the deliberate infliction of conditions of life calculated to bring about the physical destruction of the group. It does not fall within the categories of acts of genocide set out in Article 2 of the Convention, but coupled together with physical or biological destruction, it can legitimately be considered as evidence of an intent to physically destroy a group. So basically, the court said on its own, destruction of these types of properties, historical, religious, and cultural property, is not enough, but coupled with other physical and biological destruction, which wasn't present in the case of Bosnia v. Serbia, it could be evidence of genocide. Let's look at the next of the prohibited acts under Article 2 of the Genocide Convention, D, imposing measures intended to prevent births within the group. This could include sexual mutilation, sterilization, forced birth control, separation of sexes, prohibition of marriages, and it could be mental as well as physical. So members of a group could be led by threat not to procreate, and persons who have been raped may refuse to procreate. The ICC's elements for the crime of genocide by imposing measures intended to prevent births include the perpetrator imposed certain measures upon one or more persons. Such person or persons belong to a particular national, ethnic, racial, or religious group. The perpetrator intended to destroy in whole or in part that national, ethnic, racial, or religious group as such. The measures imposed were intended to prevent births within the group, and the conduct took place in the context of a manifest pattern of similar conduct directed against that group or was conduct that could itself affect such destruction.